ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. Welcome to the online lecture series being conducted by the Karnataka State Bar Council and the KSBC Law Academy. ಇನ್ನೊಂದ್ಸರಿ ಶುರು ಮಾಡೋಣ. 1, 2, 3. ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. Welcome to the Belaku online lecture series being conducted by the Karnataka State Bar Council and KSBC Law Academy. The purpose of this online seminar lecture series is to remember and also to cherish the memory of the doyens of the bar and the advocates who made a mark in the advocate's profession and continue to be the beacon of light for the younger generation in posterity. Today's lecture is dedicated to Shri A.N. Jayaram, one of the finest gentlemen and a great lawyer from the Karnataka bar. Shri Amrutur Narayan Jayaram was born in September 1930 at Amrutur in Kunigal Taluk. He obtained BSc and LLB degrees from Mysore University. He obtained his master degree in international law from the Hague Academy of International Law, Netherlands. In 1955, he began practice as an advocate. In 1986, he became a senior advocate of the Karnataka High Court. In 1995, he was appointed as the Additional Solicitor General for India in the Supreme Court and held the post till 1996. He served as Advocate General for Karnataka from 1999 to June 2004. He taught international law to students while continuing to his practice in the courts. He was a distinguished law officer who practiced for more than 50 years. He also served as the President of Bangalore Advocates Association and President of the Karnataka State Commission of Jurists. Shri A.N. Jayaram was an ardent Carnatic music lover. He also served as the Executive Trustee of Bangalore Gayana Samaja. His other interests included rural education, literature, photography, and a passion for the language of Sanskrit and Kannada. Shri A.N. Jayaram represented the state of Karnataka in TMA Pi Foundation versus State of Karnataka, wherein the Supreme Court decided on the extent to which the state could exercise control over the educational institutions. He also handled several high-profile cases, including Kaveri water dispute, Dr. Rajkumar abduction case, Bangalore Palace property dispute, and the Roris Tataguni estate case. Mr. Jayaram passed away in 2015 at the age of 84. His wife, Srimati Vinu, and daughter, Ms. Malavika, are both lawyers. I have personally interacted with Shri Jayaram when he was a neighbor in High Point. He was one of the finest gentlemen I have ever come across. The way he submitted these arguments, his mannerisms, his behavior in the court was excellent. Today's speaker, Mr. C.K. Nandakumar Sr. Advocate, he completed his BA LLB from National Law School of India, University, Bangalore in 2001. He was designated as a senior advocate in 2021 by the Karnataka High Court. He heads the law chambers of C.K. Nandakumar, which is a chamber of 10 lawyers with a focus area of commercial litigation, arbitration, domestic and international, corporate and civil disputes. The practice includes matters relating to civil and commercial suits, written regulatory matters, court intervention in arbitration, shareholder disputes, corporate insolvency, and white-collar crimes. He appears as counsel in arbitration before the Supreme Court of India, the High Court of Karnataka, National Company Law Tribunal, and other fora. He also accepts appointments as arbitrator. He is a fellow of the Chartered Institute of Arbitrators, UK. He is a certified arbitrator, Indian Institute for Arbitration and Mediation. He is also a member of INSOL International. He was selected to the ICC Advanced Arbitration Academy of Asia. He is also on the advisory committee for the International Center for Dispute Resolution. He is a regional ambassador for HK45, an initiative of the HKIAC. He is a contributor editor of C.R. Datta Commentary on the Company Law 2017 edition. He has contributed to International Construction Contract Law 2nd edition. He is a visiting faculty at the National Law School of India, University, Bangalore. He is also routinely invited to various speaking engagements. I request Mr. C.K. Nandakumar to continue the session and to deliver the lecture in the memory of Shri H.N. Jayaram former Advocate General for Karnataka.
Is under Section 9 of the Arbitration Conciliation Act, which is where you want some interim measures or interim relief. This could be either prior to the arbitration, during the arbitration, or subsequent to the arbitration. Now let us test this hypothesis. So if I have an agreement which has an arbitration clause and I need to initiate arbitration, but I want interim relief, the question I ask myself is, which court do I go to? The first port of call to decide that would be the definition clause of the Commercial Courts Act, which is, as I said, Section 2(1)(c). We look at it to see if it's a joint venture agreement which has an arbitration clause. Well, if the answer to that is yes, then of course it is a commercial dispute. And if the subject value is specified value or the subject matter of the dispute is more than 3 lakhs, then you qualify under the specified value classification. And therefore you are entitled to go to the commercial courts. But if it is a subject matter of arbitration, then what happens? The question is, and the answer to that is quite simple. It is that if you have your remedy under Section 9 that is otherwise available to you, you are entitled to file a Section 9 application before the commercial courts. But suppose the dispute that you want to seek remedy under Section 9 of the Arbitration Conciliation Act and the arbitration or the joint development agreement is in relation to a residential project, and that agreement has an arbitration clause. Then what is the remedy? The answer to that is that you do not qualify under the commercial court's definition, because you are, in view of the judgment in Ambalal's case, not a commercial dispute, because the construction and infrastructure contract, the agreement relating to movable property is not used exclusively in trade or commerce, but is for residential purposes. Therefore, you're outside the purview of the commercial court. But that doesn't exclude the jurisdiction of the city civil court or your regular district court to entertain a petition under Section 9. The difference would be that if it's a Section 9 petition that falls within the purview of a commercial dispute and is in excess of the specified value, then you go to the commercial court. If it is not a commercial dispute, or it is a commercial dispute but is below the specified value, in such an event, you go to the regular civil court. This is a distinction that one has to bear in mind. The same issue also comes up when you need to challenge the award under Section 34 of the Arbitration Conciliation Act. If you need to seek extension of time under Section 29 capital A, if there is a suit filed and you want to make an application under Section 8 for reference to arbitration, then this question simply doesn't arise, because that suit could have been filed anywhere. So that is not a question that is of that much importance. And the other aspect that has now gotten some great degree of clarity is when it comes to Section 37, that is the challenge that is available, or the appeal that's available under the Arbitration Conciliation Act. Now, there again, if you do fall within a commercial dispute, it goes to the Commercial Appellate Division. If you do not fall within a commercial dispute or it's below the specified value, then your regular civil appeal, as was originally available, perhaps earlier it used to be classified as MFA, that classification would still have to continue. This is as far as the denomination of the courts and the jurisdiction of the courts is concerned. But there's something slightly more interesting that, and of some consequence, that I thought I'll point out. When it comes to international arbitration or international commercial arbitration specifically, the definition under the Arbitration Act is where one of the parties is a foreign company or a foreign person or non-Indian person, then it's deemed to be an international commercial arbitration. In such a case, irrespective of what the other parameters are, if it is a commercial dispute and it is above the specified value, straight away your challenge or your interim measures will have to go only to the High Court. This is also pursuant to a recent judgment of the Karnataka High Court, where the High Court found that, in fact, in a very peculiar situation, the challenge to an international arbitration award, which was seated in India, and therefore the challenge has to be made within an Indian court, the challenge was being heard by the division bench of the High Court. And therefore, the appeal remedy that you had was being taken away, either under Section 37 or under the corresponding provision of the next chapter of the Arbitration Act. Therefore, the division bench of the High Court specifically passed a judicial order, also directed the registry on the administrative side to come out with a notification, and that's been done. So therefore, now you have a situation where if it's an international arbitration award seated in India and the place of the courts agreed upon by the parties is Bangalore courts, then the challenge to such an award or the request for enforcement would have to go to the High Court directly. This is in consonance with the scheme of the Commercial Courts Act as well. There's another aspect that I thought I can mention here. There were recently some statistics published about how effective or ineffective the commercial courts have been across the country. Now, I'm not too sure what the depth of that study has been, but what has been interesting is that one would have thought that Bombay would have had possibly one of the largest number of commercial cases, but that hasn't quite been the case. Delhi seems to have been the place with the maximum number of cases. The peculiarity in Bombay apparently has been that the commercial courts in Bangalore, for example, we have almost 10 or 12 courts, now 10 or 11 courts, and many of the judges are well trained. That hasn't kicked off to the same extent in Bombay because there again the pecuniary jurisdiction of the High Court, if I'm not mistaken, kicks in only over a crore of rupees. And so they've been grappling with this problem of 3 lakhs under the Commercial Courts Act versus what the High Court prescribes, and that's a problem that they've been dealing with. Now, there are a few other aspects that I wanted to now touch upon. After the discussion relating to jurisdiction and the constitution of the courts, there are a couple of other aspects which are of some significance. One is that the whole purpose behind the Commercial Courts Act was to actually expedite hearing and disposal of cases. And the whole scheme of what was contemplated and visualized and what was sought to be implemented was with that objective. Now, one might turn around and say that under the Arbitration Act, the time limit for disposal of a Section 34 petition is really 1 year, but that's not happening. It's taking a little more than that. But I'll just like to say this. I think we are still a work in progress when it comes to the commercial courts and the hearing of arbitration matters before these commercial courts. Secondly, very often arbitration proceedings involve very large and voluminous records, which make it very, very difficult for the courts to sift through some of those documents and the volumes that are placed. So there has to be that aspect that's borne in mind. But more importantly, there are many measures that the Commercial Courts Act has set in or put into place to ensure that the speed with which the case can be moved is generated, and unnecessary obstructions to those proceedings are done away with. One example is in Section 8 of the Commercial Courts Act, which essentially eliminates challenges to most interlocutory applications and also eliminates the scope of a revision that was otherwise available and obviously is available in some other states more than here in Karnataka. Having said that, of course, a regular writ petition under 227 is not eliminated. You can't eliminate it because it's a part of the basic structure. But otherwise, a principle analogous to what is set out in the Arbitration Act and the judgments of the Supreme Court in the arbitration scheme is sought to be introduced in Section 8, which is that if you suffer an interlocutory order or an order on an interlocutory application, I should rephrase that, then unless you're really aggrieved and you want to resolve it, your remedy is that it shall be raised in an appeal against the decree of the commercial court. So you wait, suppose an amendment wasn't allowed, suppose something was not allowed, you wait and then take that also up along with your main matter, which is really what the scheme of the Arbitration Act contemplates, which is that suppose you make an interim application before the arbitrator or the panel of arbitrators and they decline that application and you want to challenge it, you have no immediate remedy. You have to wait for the final award to come. and then along with that award, you question the fact that, say, for example, an amendment which you sought was disallowed. So this concept of not going to the higher courts at the drop of a hat for every interlocutory order, and giving the primacy of decision making to the commercial court is a concept that's been borrowed from arbitration, and that is something that would eliminate some degree of unnecessary challenge and stay and constancy of having to go up and down to the higher courts. There are similarly many other concepts that have been borrowed from the best practices of international arbitration and international commercial practice into the Commercial Courts Act, and this is actually a very welcome development. One example is something called a case management hearing. Another example is the use of discovery, and I'll come to that. But one excellent initiative, which I think will show dividends and show a lot of good results if members of the bar really take to it in a welcome way, is something called the pre-institution mediation and settlement scheme. Now, this was not in the original text of the Act when it was enacted, but it was brought in under an amendment in 2018. The idea is that once you wish to file a commercial case and you do fall within the purview of the commercial court, if your suit or proceeding that you intend to initiate, typically a suit, is only for recovery of money, primarily, and you're not seeking any interim reliefs, then the idea is, why not try mediation even before the matter goes into court? This way, you actually eliminate the whole process of going to court, summons, then you file written statement, you engage a lawyer, etc., etc., etc. What happens is that in such a case, they have essentially said that you cannot file a suit till you exhaust your remedy of pre-institution mediation. And somewhat sensibly, the general time that is prescribed for this is about a couple of months. And if it drags on beyond that, they realize that, okay, the defendant is just being recalcitrant, so you can proceed with the filing of the suit once you get a closure report. What happens is that you make the entire plaintiff, I think you just have to file a form with some basic fee of 1,000, 2,000 rupees. The center here in Bangalore, for example, they issue a notice to the other side and ask them to appear on a given date. And on that day, they see if there is a possibility of a resolution. And the Legal Services Authorities Act is brought into force to see if there can be a resolution. And if there is a resolution, then that has the effect of an arbitral award which you can enforce, which has the effect of a decree. And if there is no settlement, the period that you spend in the pre-institution mediation is excluded for the purposes of limitation. So in many ways, when you think about it, you don't have to pay upfront court fees. You are taking a chance to see if the matter can be resolved. And if you are able to show that the other side has been unreasonable even in the settlement discussion and so on and so forth, it could weigh on the judge's mind when an order as to costs is passed at the end of the proceeding. Really speaking, that is something that our courts need to work a little more on, and the bar also needs to be a little more accepting of. But if this mechanism is used and used well by the bar and used well by litigants, according to me, a large number of the disputes can be eliminated. I'll give you a classic example. If you have a lease which is for commercial property, and obviously the rental being in Bangalore is more than the specified value, and you want to file a proceeding for eviction, what interim relief are you likely to ask for unless you say that there is a threat of induction of a subtenant? In the most likely scenario, not of any significance is the interim order that is passed by the court. In such a case, suppose you institute pre-institution mediation proceedings, and that results in the culmination of a settlement. Imagine the time that is saved. Imagine the costs that are saved. It is so significant that it is like moving from petrol vehicles to EV vehicles. That is the level of saving that the that on the economy that you can have. Because ultimately, the whole reason why commercial courts are given primacy is because economy is of great value, and the flow of capital in the economy is what is very important for everything else in the country to operate. Because after all, without that, very much else cannot progress in the country. Now, I mentioned a couple of other aspects that are of some significance. One is that the normal civil procedure code applies to commercial disputes, except that there is a schedule to the act which sets out many changes or many amendments to the civil procedure when it comes to commercial disputes. And those changes apply. Some of these include, as I said, something called a pre-institution, a case management hearing. Now, a case management hearing is an excellent device to save time and to set the schedule. Typically, what happens is that once you file your suit and the other side appears and files their written statement, under the Commercial Courts Act scheme, there is a hard stop, which is that at the end of 120 days, if you haven't filed your written statement, you've forfeited your right to file a written statement, because that is really the language that's used in the statute. So you completely lose your right. Second, once you file your written statement, there is a concept which actually was in vogue even in the Bombay High Court original side rules for many, many years before anybody even thought of the Commercial Courts Act. But of course, the reason why they did it in Bombay was different, because there was no facility to record evidence as conveniently as there was in the courts in Bangalore at the district level, because the suits were being tried at the High Court. But there was this concept where you would go to the opponent lawyer's office for an inspection of their documents, and then you send a report, and only the documents that are not admitted or they are disputed would need to be proven. So this concept is introduced under the Commercial Courts Act, where you have an inspection and you file a list of what are known as your admission and denial of documents. Once that is done, it's only the disputed documents that you need to prove. The admitted documents need not be proved. Very often in commercial transactions, and unless there is a claim for damages or fraud or some other such aspect, if the entire transaction is documented, then really the need for oral evidence can be done away with. And imagine the saving of time in the resolution of a dispute if the entire scope of letting in oral evidence and cross-examination is completely done away with. Then essentially on the basis of the documents that are admitted by the parties, there is genuinely a dispute over, say, for example, the interpretation of a particular clause or the construction of a letter, then that dispute is really all that the court has to apply its mind to and pass a judgment. Imagine the level of focus that can be brought to the resolution of a dispute instead of generally passing a judgment of 80 pages covering all facets of the dispute, whether they are admitted or not admitted. Another aspect which I was mentioning was something called the case management hearing. Now, after the admission and denial is done, the court then has a case management hearing to assess and see whether or not oral evidence is needed, to what extent oral evidence is needed, and basis that sets a schedule to say, all right, we are today on the 20th of January, the plaintiff shall file its evidence affidavit on or before 27th of January, and evidence shall be recorded on that day. Cross-examination, if any, by, say, for example, the 2nd of February, and then the entire schedule for the case is set out. This is a practice that's been adopted from international arbitration, and it's immensely popular. Of course, what also happens is that it gives everybody clarity as to what the schedule of the hearing is, and basis that, if parties wish to say, all right, now is a good time to start the negotiation on a settlement, parties will be encouraged to do it. So in many ways, these are all sort of procedurally built-in mechanisms to try and push parties to a genuine resolution of the dispute instead of just a disposal of a case. And that's, I think, the world of a difference that a good legislation can make. There are several other amendments in the CPC which are contemplated. One such is something called the summary judgment proceeding, which is introduced in Order 13 capital A of the CPC as amended to commercial courts. Now, this is a very interesting provision. We are all familiar with the provisions of Order 7, Rule 11, which deal with the rejection of a plaint, which very often we see defendants fight. there is some potential way in which you can say that the court fee is not full, you will file an order 7. Then you are also familiar with Order 12 Rule 6, which talks about a judgment on admissions, where upon the statement made by the defendant, typically in their written statement, the plaintiff applies for a judgment on admission and says, all right, I've asked for 4.5 crores. He's admitting to an extent of 65 lakhs. At least that you pass a decree. Balance we can worry about in the trial. But Order 13 capital A is a departure from both of these. What it does is to basically enable both parties, that is either the plaintiff or the defendant, to make an application and ask for either the whole or a part of the claim or counterclaim or disposal of the case. Now, for example, the plaintiff can make an application under Order 13 capital A and ask for a decree either on part or the entirety of the suit. The defendant can make an application and ask for the dismissal of a suit or dismissal of one claim in the suit. But the primary condition is that this should be capable of disposal without oral evidence. Now, in many cases where it is used well, what happens in a summary judgment application is that you are also required to set out the issues that arise for consideration, the documents in support, and some other parameters that are mentioned in those rules. Once you do that and the other side meets that, then on the basis of what is set out, if the court is able to decide the whole dispute or a large part of the dispute, that is, to my mind, fairly effective dispute resolution, because without recording evidence, that is oral evidence, on a significant portion of the dispute or the entirety of the dispute, if the court is able to be done with the matter without being confined by the strict rules of Order 7 Rule 11 or Order 12 Rule 6, and by being able to refer to the documents that the parties place, which are basically admitted, because by this stage you might even have completed your admissions and denials, then the court can effectively be disposing of either the entirety or a significant part of the dispute without having to record oral evidence. Now, as we are all aware, practitioners in the civil court will tell you, once the matter goes into trial, then there are invariably repeated adjournments to say, today my senior is unwell, today the witness is unable to come, and so on and so forth. All of this is done away with, because the beauty is that mostly in commercial disputes, most of this is documented, especially when it comes to companies. More often than not, there is a requirement for documentation. So therefore, there is some greater degree of rigor that the parties bring to the table. This is something that reminds me of another aspect. Now, in international arbitration, for the longest time, Indian parties, it was almost a given that the Indian party in the international arbitration would lose. The reason was not that there were no good Indian lawyers or there were no, we did not have a case or anything of that sort. But the reason primarily was that Indian litigants would very rarely, or Indian companies would not be in great compliance with whatever was necessary to be done in terms of documentation, in terms of record keeping, and so on. In the recent past, there has been a huge shift, and we are seeing a lot of Indian parties initiating in arbitration proceedings internationally. And therefore, there is now definitely a change in the perception amongst corporate counsel, about in-house counsel, and so on, about how record keeping is important, how documentation is important. Now, if that same principle can be applied to the commercial court system, and the bar members and litigants are able to see that in at least in some percentage of the cases that are before the court, if these techniques and these procedures and these facilities are used, then it will certainly ease a lot of the pressure that the burgeoning dockets explosion problem has caused, and we'll be able to reduce the level of litigation that we are faced with. A few other peculiarities with the commercial court system include the necessity to file what is known as a statement of truth, which is essentially an affirmation over and above the normal verifying affidavit. And there is some greater degree of rigor that is needed when it comes to having to mention the aspects of what is to one's knowledge, what is to one's information, and so on and so forth. Now, these aspects can again enable the court or facilitate the court to take decisions without having to go into the depth of oral evidence. And very often, one must bear in mind this fundamental aspect of evidence, which is that where there is documentary evidence, it prevails over oral evidence. So no matter how many reams and reams of paper of deposition is recorded in court, ultimately if there's a document that speaks to the contrary, all that oral evidence is virtually to naught. So therefore, that time that is spent in recording 8 days of cross-examination, I mean, we've all heard legendary stories of how such and such lawyer did a heroic cross-examination and dismantled the opponent. But in a commercial dispute, the scope of such cross-examination is often limited because there is a document that speaks on a particular point. So therefore, these concepts have been meshed together to try and find techniques to resolve the dispute expeditiously. And we are today in a situation in Bangalore where, when you think about it, I mean, I'm a great votary of arbitration being a practitioner, but when you think about it, sometimes, and there are cases where commercial court dispute resolution can be even faster than an arbitration dispute. I'll give you a very simple example. If I were to initiate arbitration, I have to first issue a notice under Section 21 and wait for 30 days. If there is no response, I'll have to file a Section 11 petition. That could take 6 months, 7, 8 months. Thereafter, I start the arbitration that can take about a year, maybe a year and a half. Then comes the Section 34 proceedings, which are another 2 years or so. And then comes the Section 37, the division bench of the High Court, that's another 2-3 years. Now, if I file a suit before the commercial court, most suits get disposed of in 2 to 3 years. And from there, the appeal, which is can be a complete rehearing, is before the division bench, and that's another 2 or 3 years. So in terms of time, in terms of your ability to present the case, it's not a bad system at all. In fact, it's comparable to some of the better systems in the world. But the caveat I would add here is that it is entirely up to us as members of the bar and litigants to make the best of this facility and to ensure that this is essentially a system that we can all come back to with confidence and say, all right, if we have a dispute, we'll go to the commercial court, we'll get a decision in 6 months. That will be something that both of us are comfortable with. But for us to get to that system, we all really need to be able to cooperate and work with the system and work well with the system to ensure that we meet the real aspirations of the legislation. There are some other aspects of the Act which I have had to sort of skip over, but these are some key points which I thought I'll mention because they are somewhat peculiar from the regular civil courts practice. And with that, I'll just conclude my remarks. And if there are any quick questions, I'd be happy to take them subject to Mr. Basavaraj's indulgence.
Sir, that was a... Only 1 second. Can you hear me? Sir, that was a magnificent lecture. I was just chatting with Mr. Arun, and who informed me that Srimati Jayaram is also in the seminar lecture today. And I would like to request her to say a few words immediately after the question and answer session. Now, sir, couple of questions I wanted to ask is the latest case law, the important landmark judgments on the Commercial Courts Act. That is one. Second one is the success rate of the PIM. And the third one is how to value the intellectual property in the commercial court, because recently the Karnataka High Court has delivered a judgment that the commercial court should call upon the plaintiff to value it, because there is a tendency to undervalue it and then bring it before the civil court. The first one is, of course, if you have made notes, many juniors are asking for the latest case law on the Commercial Courts Act as such, just to know where they stand. Yeah, 1 minute. I'll do that. I'll do that. I'll do that. Yes, sir.
Thank you, Mr. Basuraj. Very quickly, I don't think there's a better person than Mr. Basuraj to offer the compendium of latest case law. On a lighter vein, say that we should all refer to Daksha Legal for the latest cases. But jokes aside, I will make 2 or 3 points which are very interesting. Now, we take it for granted, for example, in a regular civil suit, that at any point in time during the trial, I can produce a document, and that should not be a problem. But there is a judgment of the Supreme Court, Justice M.R. Shah's judgment, which has been followed by the Karnataka High Court, which essentially says that there is a departure from the normal rule under Order 7, Rule 14, where you could produce a document at any time, and we had the judgment of our High Court which said that, yeah, you should liberally allow it, there is no difficulty, and so on and so forth. Those rules are now gone. You have to therefore be cognizant of the rules of the game under the commercial court scheme, where if you do not produce a document at the right point in time, which is when you file your suit or the complaint or the written statement, your opportunity to thereafter improve your case by producing documents and say, oh, I opened a cupboard and there I found this file, my father had left it behind. All of that is going to be very, very difficult because the Supreme Court is categorical. It says, unless you're able to explain, literally like explaining the delay and limitation of every day of why you could not produce it earlier, the rigor is much higher and the threshold is much higher. Similarly, when it comes to, so therefore, to complete that point, the point is, when you look at a commercial transaction, you expect that both parties have acted reasonably. You expect both parties to have developed and maintained their documentation well. Therefore, there is a premium on compliance. Therefore, there is a premium on being able to present to the court your case in its entirety at the onset of the case and not at the fag end. What used to happen was, and I remember quite distinctly this being the practice for many years, when you are looking at the clock and you say that, okay, you're almost close to 90 days from the date on which you were served with the summons and the suit summons, you would file some written statement and then say, all right, let me just deny everything and file it. Thereafter, we'll worry about getting proper instructions and getting the full documents and so on and so forth. Unfortunately, those days are now gone, and I think it's a happy thing that those days are behind us, because there is now a need to say that there has to be some sanctity to a statement made on oath. Primarily, if you ask me, there are 2 problems. One is that we do not really have strong enough laws for perjury, and we do not have a proper regime of costs. If these 2 are implemented with some rigor, then I think you will eliminate a large part of the pendency in this country. But be that as it may, insofar as commercial courts, production of documents was one. Second, and you mentioned it already, insofar as valuation. Intellectual property valuation is always a tricky subject. I say this because very often when it comes to a trademark suit, the plaintiff will want to show how there has been a lot of expenditure towards the marketing cost and so on and so forth. But the real value of that intellectual property is a little difficult to gauge. There are today techniques to value intellectual property and intangible assets, and therefore that is something that increasingly people are looking to do. The courts, the recent judgment of the Karnataka High Court to say that you can't just casually value is absolutely right. It's something that certainly needs recognition. It's not just in intellectual property cases, but also when it comes to other commercial disputes which aren't of a specified nature. For example, if it is a partnership dispute and you're suing for accounts, then again, it is open to debate as to what that value should be. I think here again, there are some more nuances that need to be developed a little more to ensure that the valuation done is accurate and to the point, because that will again eliminate a lot of unnecessary litigation.
What is this, the success rate of PIM, Mr. Nandu?
PIM. Insofar as success rate, honestly, I do not have the statistics, but I can tell you personally, I have knowledge of a good number of cases that have been settled. My colleagues tell me that there are eviction cases that have been settled, money recovery cases that have been settled. And even if they haven't been settled within that 60-day window, it has planted the seed of an idea of settlement in the party's head. And therefore, they have been able to, soon after the filing of the suit, get into a mediation and then settle the matter. So it sometimes is the changing of the mindset of the parties and sometimes the settlement itself. I don't know if the statistics are published on the website of the Legal Services Authority. That is something that honestly I've not looked into. But my point would be that I think we need to see a greater success, and seeing a greater success is up to all of us.
Now, I have this doubt. See, when we entered the bar, I think Mr. Arun also agrees. We had this famous case of Hegde and Gole and all that. If you file a winding up petition under the Companies Act 1956, it is not a suit for recovery. It is not a petition basically for recovery of the amount. It is basically winding up of the company on the ground that the company is unable to pay the debts, etc., etc. Now, at the present scenario, is there a doctrine of election where the party can go to IBC or commercial court? Is the scenario changed as in today?
So there is an important point that you make here. Now, under the insolvency code, there are basically three categories of people who can approach the court for getting a company into insolvency. The first is a financial creditor, where the scope of dispute or the scope of objecting to a proceeding under Section 7 is very, very limited. The second is an operational creditor, where typically I've offered either goods or services to you and you've not paid me money. In such a category, if there is a pre-existing dispute, that is a valid defense to say that this matter should not go into insolvency, but it should really go to a civil court or an arbitration proceeding or wherever else. The third category is, of course, where the company itself wants to go into insolvency for protection, like the scheme of the BIFR earlier. Now, it is mainly in the second category of operational debts that this question will arise, because when it comes to financial debts, even if there's a pre-existing dispute, that has been held to be not a valid defense. So therefore, when it comes to an operational debt under Section 9 of the Insolvency Code, then you have to be careful, as especially the person initiating the proceedings before the Insolvency Code, that you do not also file a suit for recovery of money. But having said that, you also run the risk of limitation, because the Supreme Court is categorical in saying that the insolvency proceeding is not a money recovery proceeding. So if you file for insolvency and for whatever reason it's kept pending, or it is delayed, or there is no adjudication, or there is some other issue, then you have a problem. But there is something else here which is which merits one more minute of mentioning, which is that under the scheme of the Insolvency Code, what happens is that if you have a case where the petition against a particular company X is admitted, then claims are invited and I can make a claim to the insolvency resolution professional. Therefore, all the claims that I may want to make in a suit, I could always make before him or her. Secondly, once a company petition is admitted and the insolvency process starts, there is something called a moratorium that applies. So even if you have initiated a suit, that suit stands stayed if it is against the company. So therefore, these aspects have to be kept in mind while deciding the strategy on a case-to-case basis as to whether you should approach the commercial court or you have a fit case for insolvency.
If you're looking for money, it is
because in insolvency, sometimes the medicine is worse than the disease. You will have to be careful.
Yes, that's what I was thinking. Anyway, the Commercial Courts Act has brought in a new wave of efficiency and speed. Only the new generation of advocates who are already have that killing instinct and energy, they would like to practice on the commercial court, because once they switch over to the average, the normal litigation, I think they'll be thoroughly disappointed. Anyway, compared to thanks to the Salem Bar Association case, the written statement has to be filed and everything is streamlined. But the kind of speed and the energy and the wave of the new paradigm shift the Commercial Courts Act has brought in, that will only encourage the juniors to take up the litigation side when compared to the behind the desk job. Now the lines are open.
I just have one response to that, which I'll keep it quick. I think there is one advantage also with these commercial courts, which will have a ripple effect on the regular civil courts. The point is simple. it's the same judges who sit as your regular district judges or city civil judges who are sent to the commercial courts after some training. When after that stint at the commercial court, they go back, many of the practices of the commercial court, they will want to use in their regular civil disputes as
It should
well.
not be
And
the
they will
other way,
want to,
fortunately.
even if not, you know, exactly. And also the members of the bar who are accustomed to the practices there will be able to find better techniques to try and say that,
That's
you
good.
know, a matter can be resolved more effectively.
That's really
So I think in many ways it's a perception or a attitude change that is being brought about by measures such as this.
No, commercial code, even the judges, they are so, result oriented. In one of the eviction cases, the matter was sought to be settled because of the intervention of the honorable judge. And the honorable judge, when the other side was not there, my friend, Mr. Madhukar Deshpande, the judge took the telephone number and called from her cell phone and saying that this is the condition I'm imposing, you have to agree. I think Judge Lata Kumari or something, she's very, very efficient. Then he was, no, I'll come there. No, don't worry. I'm calling over telephone. This is the point I'm going to incorporate. You have to agree for this. So ultimately, by the end of the telephone conversation, the matter is almost settled. This is the kind of efficiency and the paradigm shift we are looking for, especially in because the commercial transactions are they decide the nerve of the nation, and that cannot be delayed under any circumstances. And now the lines are open, and I request the participants to ask the questions by opening their mic and also the video. In the meanwhile, can I ask Srimati Venu Jayaram to speak few words about because I was your neighbor. I was in High Point 4 and I used to see Mr. Jayaram every day, who was adjacent. I was with Mr. Vijay Shankar. So I request Srimati Vinu Jayaram to say a few words if you can. Madam, can you? I think the lines are Mr. Let me. Gautam, can you open the? Can you unmute? Is it okay? You cannot unmute. 1 minute. Yes. Now you can unmute. Yes. Now the participant can unmute yourself and also start the video. You can ask the questions. In the meanwhile, I request Srimati Vinu Jayaram to say a few words. Any questions from the participants? I think you covered the subject so exhaustively. No questions or doubts are left, I think.
Sir, I have one question to ask.
Yeah, Mr. Naveen,
May I, sir, please? Yes, sir. I wanted to know, this is with regard to the Section 9 of the Arbitration Act. So when we are seeking an interim relief, I just wanted to know that whether a subsequent Section 9 petition can be filed before the same judge with the same parties, whether the res judicata will apply to the Section 9 petitions.
I mean, I don't think it's quite within the scope of what I was discussing today, but nonetheless, the short answer is that there are judgments of the Karnataka High Court which say that res judicata applies even to interlocutory proceedings. Section 9 proceedings are essentially in the nature of interlocutory proceedings. So therefore, by analogy, the same principle would apply. But having said that, much like with a bail, if there is a changed circumstance, then it's possible that you will look at and then say that, look, I asked for it then, you declined, but now there is this development, therefore can you please re-indulge me? There is one important aspect you must remember. Section 9's scope has been cut down by the amendment to the to the Arbitration Conciliation Act, because the idea was that they wanted to remove court intervention to the extent possible. So therefore, the remedy under Section 9 is now really a somewhat limited remedy, because if you have an opportunity to go before the arbitrator, the civil court is excluded from taking up that matter. So what are the chances that you will file today and then in another 3, 4, 5 months have a changed circumstances and a need to file a fresh one, the chances are a bit dim. But maybe in a post-award but pre-enforcement scenario, you might have a situation where you could file a second one because of changed circumstances. That is one possibility that I can say.
Thank you, sir. Thank you so much. My
Thank you.
friend is with me. He's also want to ask one more question. So please permit us.
So I'll just start my video. My name is Harish. Thank you for your
Hello.
speech.
My pleasure.
So my question is with regard to the cases that have been transferred from the civil court to the commercial court. So what has happened is that when you had filed the suit, for example, in the civil court and it was running in the civil court, prior to being reclassified as a commercial suit, you would have filed the plaint in a certain manner or written statement in a certain manner and not thought about the strictures or the rigors of the Commercial Courts Act, at least insofar as production of documents or many other aspects. Then it had got reclassified, then it comes to the commercial court and suddenly you have to do so many things. You have to file statement of admission and denial. You maybe want to produce documents now, but then you're hit by the rigors of Order 11, which is something that had happened in a matter as well. So sir, do you think that at least insofar as right now that there should be probably a buffer period where the strictures that Order 11 prescribes or the other strictures that are there in the Commercial Courts Act, perhaps they ought to not take the ultimate, the most strict view, or even with respect to filing of, let's say, written statement, which would not have been filed for many years in a suit, and then suddenly you'll come with a condemnation of delay for 6 years, and then you'll say, no, now I'll file. So what do you think about that, sir, this aspect of the commercial courts?
I mean, the complete answer to your question lies in section 15 of the Act. But there's a reason I didn't mention this. The reason is that we are now a few years into the operations of the Commercial Courts Act, and most transfers that needed to be done are already done. So I didn't think it was really that current or that live a topic for me to spend some time on, but I'll just take a minute and quickly answer your question. Well, the short answer is that the section itself clearly says that it shall continue from the stage at which it was transferred, unless, of course, it is already reserved for judgment, in which case it will not be transferred. Now, if that stage is for filing of written statement, then from that point on, once you get the transfer and you are before the commercial court, from the first day that you're there, or from the day that the transfer occurs, you can take it that your clock starts ticking. And if you haven't filed documents, good time to compile everything and file it immediately. If you haven't filed a written statement, do it with absolute speed that you can, and so on and so forth. Now, there is one judgment of the Karnataka High Court, I had an occasion to appear and I can't remember the name, which also says that once there's a transfer, the one thing that you must do is to have a case management hearing. So if it's at the stage of trial, the court still does the case management to see what further needs to be done and then sort of organizes its file and its schedule. That's the other thing that you might be able to take advantage of.
Okay, sir. Thank you.
Thank you.
I was trying for Madam Vinu.
I am getting, I have told Andy to send our number. I have deleted a number by mistake. About Mr. Jayaram, I will come to Nandakumar start in 1 minute. Yes. About Mr. Jayaram, he was a very dear friend of my senior Shantaraju. Culturally and otherwise also spools. They both had that spools. They used to exchange that spools. I used to go and deliver spools to his house. And then one interesting matter I did when he was the Additional Solicitor General of India was these company matters. He used to entrust to Shantaraj sir, and I had an occasion to deal along with him. Extraordinary matters. One matter where Ramesh Pai was going to be removed as director of Manipal Group, chairman of Manipal Group was going to be removed. He started arguing before the Mayal court. In half an hour, they cancelled the meeting in the Manipal Group and they said he is not going to be removed today. The style, and I still remember the day when he argued. I said, then he said, after 2 months, hey Arun, our Ramesh Pai, Naninda Ulkondidarappa, chairman. Brilliant. And drafting, extraordinary drafting. Unity Buildings, he has drafted the document for the London Missionary Society in 1966 or 67. And Altamas Kabir, Chief Justice of India, former Chief Justice of India, had come here to assist him in his office in Bangalore. So Jayaram sir sat with him and drafted that document. I have not seen any document like that. It is class international. This one, the way the unity buildings and other properties of Church of South India were merged into a transfer deed. Nobody could have thought such kind of documents could be executed, and lot of interactions with him. A gentleman, a statesman, a wonderful human being, pleasant English and extraordinary Kannada.
And
Family also.
great looks. One of the
And
finest
yeah,
gentlemen, well dressed.
Nandakumar, yeah, Mr. Nandakumar's talk, he is 100% right on the point that many of the matters in commercial court are better off than in arbitration matters. I did one ejectment suit after doing extensive research how ejectment suit is maintainable before a commercial court. And then this Justice Bhanumati and Justice Bopanna's judgment came to my aid. I filed it within 3 months. Ejectment suit is decreed. 4th month, I get possession of the property.
Oh, that is magnificent.
And the judge, every time there was an interaction between me and the judge for 1 month. Then the judge, district judge said, thank you very much for this interaction. I am so pleased with the way we conducted the matters. Very fine judges. Some of the judges are very fine there in the arbitration, commercial courts matters. And thank you for that information regarding insolvency code and commercial code, Nandakumar.
That's
excellent.
A very tricky scenario.
I'm so pleased.
You go for something and end up with a disease. That's an excellent. You have to choose your medicine very carefully.
Very pleasant lecture. Anybody could understand what is commercial code, what's the benefit. I am so pleased.
Do you think that the 3 lakh should be something like at least 25 lakhs, something like that? Because the company court, I think under the Companies Act also the amount was increased recently.
No, so under the Companies Act,
all sorts of matters will come. 3 lakh is even.
That's right.
Today,
I certainly think it needs to be increased.
Even a watch cost starts with 3 lakhs. Therefore, 3 lakh is a very bigger amount. Should be something.
Perhaps the watches that Mr. Basavaraj wears, but jokes aside, you're right. Jokes aside, you're right. I think there's certainly a need to look at these numbers once again. Even for the Karnataka High Court classification of what goes to division bench, what goes to single judge. Do you need that distinction at all? These are questions that I think we need to ask ourselves. But having said that, even the Companies Act scheme, now for insolvency court, the threshold is 1 crore. So in some ways, that's not comparable with what is going on in the Commercial Courts Act. So there is a need to relook.
Cases which are before the small cases court will be shifted now to the commercial court. That is my opinion. Of course, they are already being shifted.
We have an authority on the Commercial Courts Act also.
Prashant Chandra sir. Mr. Prashant Chandra sir, a few words on the subject. And also your association.
No,
Jayaram, Mr. Association.
I'm sorry, I joined in very late.
No.
So one man is at least completed. I don't want to start now.
No. I was asking you to speak about Mr. Jayaram, your association with Jayaram and all that. I didn't know that he's from Tumkur, my district.
Correct. I had known Jayaram very well. My father was from the judicial side and he had retired. After his retirement, my father was made an arbitrator in some cases by Mr. Jayaram. And in that connection, he used to come to my office at Jeevan building, where you are there, Mr. Basavaraj. I used to share a 3rd floor building where my brother was there, Sharath and Company, you know. My father was also doing the arbitration there. Jayaram used to come there all the way to attend that case. A very nice gentleman to the core. And when he used to come there, he used to sit with my father. And after that, he used to sit, talk to me. The way he used to treat the juniors, how he used to talk to them, that all of us have to learn from him. One of the finest gentlemen I have come across, that I would say.
When I enrolled in 88, I think he was the president of the Advocates Association. I would never miss the Advocates Association meetings, the way he would speak.
Correct.
A.G. Shivanna was the secretary and he would be the president those days. That was the golden era of the Advocates Association. And the
Correct.
whole purpose of this Belaku is to recognize and remember those people who continue to be the beacon of light. We had the seminar on Mr. Baira Reddy, Mr. Bhujangrao, Mr. Vasudev
Correct.
Reddy, and now Mr. Jayaram. Mr. Udayawalla sir agreed to deliver the lecture on 10th of February in the memory of Mr. R.N. Narasimurthy. And Mr. Justice Sadashiva sir has agreed to deliver the lecture on Shri Ithirajulu Naidu. So these names, even forget about the contemporaries, even the older generation, they've already forgotten the these giants of the bar and principles they cherished over a period of time. It's high time that we remember and try to at least follow a couple of principles they stood for. So on behalf of the Karnataka State Bar Council and also KSBC.
Absolutely.
On behalf of the Karnataka State Bar Council and also Karnataka State Bar Council Law Academy, I convey my heartfelt thanks to the today's speaker, Mr. C.K. Nandakumar Sr. Advocate, and also learned participants, Shri Prashant Chandra, another senior lawyer from Bangalore, and Mr. B.M. Arun, senior lawyer from Bangalore. So on all the participants, with another subject and with another distinguished speaker, we shall meet again. Till then, Shubharatri.
Thank you
Thank
very
you.
much.
Thanks.
Thank you so much. Thank you.